Hi everybody, this is Mike and this is Module 6 in the Your Money, Your Goals Toolkit on dealing with debt. And before I get into the module, I just want to start out with my standard announcement. If you are a WISA and you were certified through Cornell, you can count your participation in this archived webinar today as part of your continuing ed credits. If you have any questions about how to access your portal or how to log in your continuing ed credits, you can email Michelle Elvert at msa224@cornell.edu, and Michelle can walk you through the process of how to log in those credits. And I wanted to start out this webinar by going through a hypothetical case study as I've done in past webinars. I feel like maybe the concepts in the toolkit are a little bit easier for folks to understand if you have a hypothetical scenario. And this is a really interesting module, and we've all dealt with debt and we've all had clients that have to deal with debt. And so I think you'll find a lot of the tools in this module to be very helpful in the work that you do with your clients. So let's just start by going through the case study first, and then we'll go through some of the tools. So I give you the case study of Tom. So Tom was recently approved for SSDI, Social Security Disability Insurance, in the amount of $1,500 per month due to various disabilities acquired in an automobile accident. Prior to becoming disabled, he had a good job and was able to keep up with his mortgage, car payment, credit card bills, and other living expenses without difficulty. He had a good credit rating and his credit to debt ratio was low. He could no longer do his job after his accident and applied for disability benefits. His disability claim was initially denied at the initial application stage and he had to appeal. His claim was awarded after an administrative law judge or ALJ hearing, but the hearing took 2 years to schedule. So during that time between the denial and the hearing coming up, the client was without income. Tom had no choice but to live off of credit cards during the time that he'd been waiting for the hearing to come up. Now he is deeply in debt, overwhelmed, and frustrated. How can the tools from the Your Money, Your Goals Toolkit help him manage his debt? And we'll go through those in just a minute. And this might sound like a familiar scenario. I had a lot of clients that were really in this situation when I was doing direct services where they were without income when they were waiting for a Social Security hearing to come up, and they were had no choice but to go into debt, borrowing against credit cards and getting loans and that sort of stuff. And by the time that their benefits got approved and they got their back pay, it was all gone to go towards paying debt. So this is unfortunately, something that's pretty common in real life scenarios, not just hypotheticals. But let's just go through some of the tools in the toolkit. And Module 6 starts on page 185 of the Your Money, Your Goals Toolkit, and it starts out with a very basic explanation on what is debt. So debt is essentially the money that you owe to another entity or another person. It's money that was borrowed and now that needs to be paid back. Very straightforward. We all know what debt is. But what it does is it breaks down for clients that might not be aware of it, the idea of good debt versus bad debt, which I found really interesting. And, good versus bad debt is also a matter of opinion and perspective, I think, too. In the Your Money, Your Goals Toolkit, some of the things that they label as good debt are things that can help a client achieve their goal. So, for example, borrowing to further the education. That's an example of what could be considered a good debt. They are going into debt to go to school, but ideally they would have the opportunity to get a degree in their field they go to school for once they graduate, be able to get a good job and be able to make those payments without getting behind or in arrears. Another example, a good debt might be able to taking out a loan for a car. People need a vehicle to get back and forth to work, back and forth to school. They have reliable transportation that increases their likelihood of getting suitable and stable employment, and it increases the likelihood of them being able to pay back those debts. Borrowing money to start a business is another example they give here. It's an investment for the client's future. And also taking out money to buy a home is another example. These are all things that can be considered a good debt, a positive step, but sometimes circumstances happen in life that makes it difficult for people to pay back the things that they take out loans for. They have intentions of it being a good thing, and sometimes life happens where it's difficult for them to be able to pay it back, and it turns out to not be such a good thing. So next section talks about secured and unsecured debt. This is pretty straightforward, and anybody that's listening to this is probably aware of this, but your clients might not be aware of the difference. So secured debt is an asset that has something attached to it. So for example, a home loan. Somebody takes out a loan to buy a home. As long as they make the payments on time, everything's great. But if they fall into arrears, the bank has the ability to repossess the home. Same thing with an auto loan. If somebody falls behind in an auto loan, the auto loan could be repossessed. Pawn loans, if a client pawns something, they're not able to pay back the pawn loan within a certain period of time, then the pawn shop would take possession of whatever item they pawned. These are all examples of secured debts. Unsecured debt is something that doesn't have anything attached to it, and they give you some examples here like credit card debt from an unsecured card, department store charge cards, medical debt, and student loans. These are all things that don't have anything attached to it. In other words, there's nothing for the lender to repossess. So these are just examples of debts that if a client was to fall behind in, it would go immediately to collections. Handy section here on how much debt is too much debt. And it says, one of the ways to know if a client has too much debt is based on how much stress the debt causes them. If you are worried about your debt, then you have too much. A more objective way to measure the debt to income ratio is to compare the amount of money that you pay out each month in debt payments to your income before taxes and other deductions. And there's a tool that you can give to clients to help them figure out their debt to income ratio that I'll go through in just a couple minutes. But basically, if a client has more going out than they have coming in, then obviously their debt to credit ratio is too high. And it gives some examples of bills that a client might have that's not necessarily considered a debt, like a rent, putting money into a savings plan, or maybe an ABLE account if they have a disability, taxes, health insurance, utilities, food, clothing expenses, childcare, healthcare expenses. These are all things that are out of pocket expenses that might not be considered debt. And we'll go through tool number 2 in a minute on the debt to income worksheet on how clients can figure out how much debt they have in comparison to their income. Wanted to take a minute to highlight the section here that they have on cosigners and agreements to repay a loan. So we all know what a cosigner is. So let's say, for example, somebody has a child that doesn't have enough credit to take out a loan to go to school, and the parent decides to co-sign for that loan. Basically, what the parent is saying is that if the child does not make the payments, if they fail to make the payments, then the parent is responsible for the loan. So the co-signer is basically vouching for the borrower, saying, I trust that they'll pay it back, and if they don't repay it back, then I have an obligation to do so. And the sad part about this is that I've actually encountered this in a lot of different scenarios, and this is something that you all as service providers for people with disabilities may have encountered too. I had a client one time who was very severely mentally retarded, and she had a fifth grade education, and that's about all that she was capable of learning. She was on welfare. She was going for Social Security, but Social Security inevitably said there was work that she could do, and she had to appeal her denial. So in the meantime, while she was on welfare, her sister took out all these credit cards in the client's name that had the mental retardation. She didn't have the credit, and so the client co-signed for that. Inevitably, she obviously didn't understand what she was co-signing for, but then the client's friend came to me and said, "This is what happened. You know, the sister took advantage of her. You know, now she's got these debt collectors after her, and you know, I had to smooth everything over with the debt collection agencies." As an advocate, explained that she was disabled, on welfare, didn't have the ability to repay. Eventually, we got it all straightened out. But unfortunately, that is a debt trap that people tend to fall into, especially if they have disabilities. They may have people, unfortunately, that do take advantage of them. So that's something that people have to be on guard for. And if they're going to co-sign for somebody, they really need to make sure that they can trust that person 100%, and that the person really does have the ability to repay the loan, because otherwise they could be on the hook. Another section here on payday loans is another situation that our clients often find themselves in. So money is tight, you know, maybe the time between the pay periods is um, too long between pay periods, rather, and they don't have any money on hand. They need money in a hurry, and they borrow against their paycheck. They can get a quick short-term loan for generally $500 or less, and then the payday loan has to usually be repaid within, I believe it's like a 2-week period, with fees and interests. So um, a lot of our clients, especially if they're on SSI or Social Security and don't really have much other forms of income, they need cash in a hurry. They might not have a choice but to do a payday loan. And there's a tool at the end of this chapter that talks about the different ways to pay for expenses that come up in an emergency. And you'll see as we go through it just how difficult it is for clients to repay these payday loans with all the fees and interest they charge. And it says the cost of the loan or the finance charge may range from $10 to $30 or more for every $100 borrowed. And then a typical 2-week payday loan is $15 per 100 borrowed fee, equates to annual percentage rate of almost 400%. So, you know, yes, they're got the cash in a hurry to pay for the emergency that they need, or what have you, but they pay a lot more out in the long run doing that option. And unfortunately, it's a debt trap that a lot of people fall into. But how do the payday loans work? There's a helpful little chart here that it might help your clients to understand exactly what they're getting themselves into when they do a payday loan. Might be helpful to point their attention to this on page 192 of the toolkit. So this just gives you an example of how a typical 14-day payday loan works. So the borrower visits the storefront payday lender and completes the application. There's no credit check or ability to repay the loan that's really dug into, and that's part of what makes the payday loan so desirable to a borrower, is that, you know, if they're in a situation where they don't really have any savings and they're going to a payday loan, it's probably because they don't really have good credit, and then they know that they don't have to worry about doing a credit check for a payday loan. They just know that this is a way to get money in a hurry. So they go to the payday loan store, do the application, no credit check. The borrower gets the loan. The median loan amount for a typical loan is about $350 and pays $10 to $30 per $100 borrowed, and $15 per 100 if the median front for payday loans. So they have a fee to do the payday loan plus additional interest and charges. So the borrower provides the lender with a 14-day post-dated check for the amount of the loan and the fee. So for example, it's $350 plus $52.50 equals $402.50. So already, just in a 2-week period, that that original loan has already jumped up $52 just based on the fees. And if they take out a loan for longer than 14 days, it's obviously going to be a lot more. So in 14 days after the date that the client takes it out, the loan is due, and if the borrower does not have the $402.50 to satisfy the debt, he will pay the fee again, which is another $52.50 on top of the fee that they're already on the hook for. So if the client has not the ability to repay within the 2 weeks as they agreed to, then they're on the hook for another fee. Excuse me, I just need a drink of water. All right, so every 14 days that the loan is due and unpaid, the payday lender has the ability to add additional fees on top of that. So every 14 days, the borrower must pay the amount in full or renew the debt by paying another fee of $52.50. It says the average borrower takes out 5 loans in a row before being able to repay and then not borrowing again shortly thereafter. Applied to this loan example, that would mean a fee of $262.50 to borrow $350. So, it might not seem like a lot, $52 in fees if the client can pay it back in 2 weeks. But what they're saying here, and this example is, in a lot of situations, it's found that the client isn't able to repay within the agreed time period, and then the fees end up being almost as much as the original loan. So that's another unfortunate debt trap that our clients fall into, and showing them this example might help them understand what they're getting into and help them avoid some of those traps. Here's some helpful misconceptions about payday loans that might also be helpful for your clients to see. It says if you're thinking about using a payday loan, it's important to be aware of common misunderstandings about the loans, that they're only to be used for emergencies, and it says most borrowers do not use their first loan for emergency expenses. Recent study found that only 69% of first-time borrowers use the loan to pay regular bills, while 16% use them for emergencies such as car repair. So it might not just be in a situation that they need money in a hurry for an emergency. They might just be short of cash and be desperate. Borrowers can pay back the loan without reborrowing, and then it says, well, they may pay it back on time. Many borrowers have to either immediately take a new loan or take another one in the same pay period. On average, the payday borrowers are in debt for 5 months out of the year and pay an average of $520 in fees on top of the money they have borrowed. So that doesn't necessarily mean that that would happen to a client that you're working with. They had the ability to pay right away, but more often than not, people are finding themselves in this debt trap. And this is how to avoid a debt trap. A debt trap is a situation in which people take a loan and they have to repeatedly take new loans to make the payment on the first loan. So that old expression, robbing Peter to pay Paul, that's often what people are in the situation having to do if they don't have enough money to go around. They take out something like a payday loan, and then they take out another loan to repay the first one, and before they know it, they're in over their heads, and they have no way to pay back what they've taken out. Payday loans are small dollar loans, generally $500 or less. They have to be repaid quickly. Again, 14 days is the typical payday term. And it requires the client to give the lender bank account information so the lender can take payment from your bank if you fail to repay the loan. And so that's also a tricky situation. If the client is responsible for giving the person like a post-dated check and the check bounces, well, then the lender has the client's bank account number and can, go in and take the money out, and that could cause some additional problems with overdraft fees and stuff like that. So that's something that people need to be aware of. So what are the alternatives to doing something like a high cost credit or like a payday loan? It says if you are short on cash, consider some alternatives. Use your own emergency savings. And unfortunately, a lot of the people that we're working with, especially if they're on SSI only and they're living on $750 a month, they're likely not to have an emergency savings fund, and that's why they find themselves in this situation in the first place. So that might not always be the best option. Use a lower cost or short-term loan alternative from a credit union or bank. That could be an alternative to a payday loan. But again, a lot of the people that are using payday loans are going to a payday loan lender because they don't have the credit to go to a bank or credit union for a loan. Borrow from a friend or family member. Maybe they could do that. Use a credit card. Well, it will increase your monthly payment. It could be cheaper in the long run, less interest, less fees. But again, that's just adding more debt on. It's not really solving the problem. Negotiate more time to pay the loan if the bill is due. Now that could be something that could be possible. And think about what you are borrowing the money for. Is it a need, obligation, or a want? If it's a want, consider whether it's possible to spend less money for it or not purchase it until you have the money to pay for it. And that's really a practical tip for people who really want things immediately, is to be patient and just wait till they save up enough money for it. But unfortunately, that's not the society we live in these days. A lot of the people that we're working with, want what they want when they want it, and they're not willing to wait until they can afford it. They'll just go out and do something like take a payday loan out and spend more money in the long run. So these are just some common things that clients should look out for and be aware of when considering how to pay for purchases or items that they need. And excuse me, I just want to take another drink. I need water when I speak. I'm sorry for the pauses. So going back to the example of what they give you above, is a client takes out a payday loan for $350 for, let's say, an auto car repair. So on this chart, you'll see different options. So emergency savings, credit card, and payday loans. And it'll give you some different things in terms of the APR for those things and the repayment terms and the interest. So let's take a look at this. So if a client needs an emergency car repair of $350, obviously the best thing to do if they have emergency savings is to use that. Obviously, if they're paying cash for something, there's no APR on it. There's no repayment terms because they're paying in cash. They're not putting out anything in total interest and fees, and the cost is only the flat fee of the $350. However, if they don't have an emergency savings, like a lot of the folks that we work with don't, and let's say they have to put it on a credit card, the annual percentage rate is probably at least $15.99, and that's kind of on the low end. Obviously, depending on the client's credit score, they might have higher interest than that, but the repayment terms is that they must pay a certain amount or a minimum payment per month. The example that we use is a minimum payment of $25 a month. So they're paying $40 in interest and fees over a 16-month period. And that's just for the $350 for the car repair. Obviously, if they're using the card for other things on top of it, they're going to be paying even more than that. But this is just an example. So they got to repay it within 16 months, and then the cost of the repair jumps from $350 to $390. Still not bad, but not as good as it would be if they were able to use savings for it. Let's look at the payday loan example now. Same $350 needed for the car repair. Again, it's $15 fee and interest for every $100 borrowed for 14 days. This means a 391% APR, which to me is just absolutely staggering. So they have to repay the loan amount back of $350 plus a $52.50 fee within 14 days. And then the total interest and fees is $52.50 for every 14-day loan. They only have 2 weeks to pay for it, but then the cost of the repair jumps from $350 to $402.50. So that's just a kind of straightforward example to show people how they can be paying out a lot more in the long run with these payday loans. Now this is a helpful section on how to deal with the debt collector, and it gives clients some practical tips on what to say if they get a debt collector call. And it says, sometimes when the phone rings, it's hard to know if a caller is a debt collector. To avoid falling victim to a scam, ask for the name, number, and address of the debt collector and request the information about the debt in writing. So if a client gets a call from, let's say, ABC agency saying that you owe X amount of dollars, if they don't know where that debt came from, or if they agree with the amount that says that they're owed, then the client has the ability to write a letter to that agency asking for verification of the debt and the amount to make sure that it's a valid debt. A lot of the times, if people have pretty severe disabilities, or sometimes you hear this happening with the elderly, where somebody will pretend to say they'll be from the IRS and say, well, you owe the federal government X amount of dollars and we want payment now. You know, I've had clients that have fallen for that trap before, where scammers have called up and said you owe this debt, and because they said they were from the IRS, the client paid the money and it was a total fraud. So clients should be aware that if they don't recognize the name of the company or the debt or the amount says that they're owed and the person is asking for payment right then over the phone, that should be a red flag, and they do have the right to send a formal letter to the company asking them to verify that debt and the amount. And be wary of sharing your personal information over the phone. You know, debt collectors will never ask for your social security number or date of birth or bank account information. This could be a red flag. Those are things from a legitimate debt collector. They would have the information on the debt that's owed in front of them. They would have that ahead of time. They wouldn't need to ask the client for their social security number or date of birth or any personal identifying information because they would already have that. So obviously, if somebody calls up that's a debt collector and asks for that information, that could be an indicator for the clients to know that it could be a scam. And again, it talks about what I was just saying is that the clients do have a right to verify a debt when they receive a phone call or a letter to make sure that they're paying the right person the right amount of money owed. And then once the debt is paid, it's important to request a receipt so that the client can prove that they repaid the debt if it ever comes into question. Kind of like what we tell people to do when they report their wages to Social Security. Social Security is supposed to give the client a receipt that they paid, or that they reported their wages rather. Same thing in a debt collector situation. They should be giving clients a receipt if everything is legit to prove that they paid. And it says, even if the client owes a debt, the Fair Debt Collections Practices Act gives the client the right to tell the collector to stop contacting you. Once you make this request, the collector can contact you to tell you that they will stop, or they may notify you that they or the creditor plans to take action like filing a lawsuit against you. After that, they must stop all contact by phone, mail, or otherwise. Stopping contact does not cancel the debt. But what it does mean, though, and clients need to be aware of this, is that bill collectors do not have the right to harass them or constantly call them. If it's a situation where, let's say, a credit card debt goes unpaid, and then the company sues the person, at that point it doesn't cancel the debt, but the collectors are supposed to stop contacting the person at that point and not harassing them. Just because somebody owes money or falls behind in their bills does not mean that they have the right to be harassed about it on a regular basis. So next section gives some helpful hints on what to do if a debt collector sues you. And most important thing is obviously don't ignore court documents. I think sometimes the people that I used to work with do get intimidated by things like this or by Social Security letters. And we've probably all been there where a client says, oh, I got this letter from Social Security, but I didn't open it because I was afraid of what it was going to say, that kind of thing. Same thing with court documents. Do not ignore them. And because essentially you'll be ignoring the lawsuit. And if it's not ignored, if it is ignored, if a person does not contest the lawsuit, then they're just accepting it, and the judgment will be entered against the debtor for that. It could be an example where somebody's sued, but there's the wrong information on the court documents or the wrong amount, and the client does have the right to contest a lawsuit, but they have to do it in the right way and not ignore the documents, because if they just ignore it, then the court will assume that the client agrees that they owe the money and then put the judgment against them. And so if it says if a client disputes the debt or the amount owed, they should do that in the court action before the court makes a judgment. So you may lose the ability to dispute an amount that the court says you owe if they do a judgment against you. So judgments against you give creditors and debt collectors much stronger tools to collect a debt from you, depending on state laws. And it gives you some examples on some of the ways that benefits can be garnished, or debts can be repaid, rather. One is by garnishing wages, placing a lien against your property that might prevent you from selling it, garnish or freeze the funds in your bank account. And while there is an appeal in process after a judgment has been entered, you have a much better chance of fighting a collection in court if you defend the case before the court decides. So in other words, don't ignore the lawsuit, respond to the court documents. If there's a discrepancy or a grievance that the client wants to follow and file, then they need to do that timely. And so because we work with people on benefits, it's important to note that, like, if they're on supplemental security income or SSI, benefits cannot and will not be garnishment to repay a debt. And the reason is because the benefits are needs-based, and just because they are based on need, a debt collector cannot go against an SSI check to collect a something like a credit card debt or something like that. Now, it's a different story if somebody's on SSDI and they have a debt like a loan or child support or anything like that. Those benefits can be garnished because SSDI is not based on need, but it is just based on disability and work history. So while SSI is protected from garnishment, SSDI is not. Just an FYI for your clients that have questions about that. And it says the client's right in the debt collection. And like I said a couple minutes ago, just because somebody has a debt does not give the debt collector a right to harass them or repeatedly call them or swear at them or publish a list of people that owe a debt. They have to identify themselves when they call you and why they're calling, and they can't obviously lie or mislead you. It's illegal for these things to happen. And it says a good idea is to keep on file all the letters or documents that a debt collector sends you, or in this case, a client, and keep a copy of everything you send the debt collector. If you send in proof of payment, send only a copy and keep the original, and record the dates and times of your conversations. So in a lot of ways, a lot of the tips that the Your Money, Your Goals folks have put together in this module are kind of the same things that we tell people that are on Social Security. So, like, for example, if you report wages, keep a notebook of when you reported, who you talked to, what the date was, what the time was, how you reported. Did you do it in person or by certified mail? We tell people to keep copies of everything that they send in and copies of any receipts or anything that Social Security might send back. So same thing kind of in a debt collector scenario. It's good practice for people to keep organized records. Next section is on medical debt, which I'm not going to go into in a lot of detail because I want to get to some of the tools. But it talks about ways to avoid medical debt by maybe purchasing additional insurance above and beyond what Medicaid and Medicare might cover, or certain medical providers have like a charity care program or they'll discharge an amount of debt for somebody that's low income. Or maybe a client can set up a payment plan with no interest, and some providers will do that. If a client is diligent on making the payments they agreed to, they would allow the client to repay the debt over a period interest-free. Well, these are just some tips that clients can follow to maybe avoid getting into debt for medical bills. And next section is on student loan debt. I'm going to go through that more detailed in just a couple minutes when we go through the tool on student loan debt and the focus on people's with disabilities guide. So I'm not going to do that right now. Debt settlement services. It says, should a client use a debt settlement service? And those are companies that can negotiate or settle an amount of debt that a person has and maybe change the terms of it on a debt. So maybe helping a client work out a payment arrangement, or paying it back at a lower interest rate, or reducing the balance owed. And a lot of the times a client could do that by contacting a debt collector on their own and negotiating their own payment arrangements or agreements without using a debt settlement service. And it says some common things to avoid. This is another example of a debt trap, is for clients not to use any of these companies that promise to help you settle your debt if they charge you a fee before your debts are settled, or touts a new government program to bail you out of credit card debt, or tells you to stop communicating with the creditors. That's something that clients should never do. They need to be in contact with their creditors at all times. Ignoring situations does not resolve anything. Tells you it can stop all debt collection calls and lawsuits, and guarantees that debts can be paid off for pennies on the dollar. These are false promises that a lot of companies use to get people's business, and then they don't follow through. So these are just some helpful tips and hints that people might benefit from being made aware of. So the first tool I want to go through is the debt worksheet. And so it says, before you start making a plan to pay your debt, you have to know where you stand. You can start by making a list of who you owe the money to and how much you owe them. This is the first step in managing and reducing your debt. So, obviously the first step in making or getting debt paid off is to know who you owe and how much. And it says, be sure to include debts to family and friends, credit companies, banks, department stores, payday lenders, court-ordered child support, local, federal, and state government, for property taxes and back income taxes. These are all examples of debts. And it says, to complete the worksheet, you will need to get all your bills together in one place. And for each debt, you will need to know the person, business, or organization you owe the money to, the amount you owe them, the amount of the monthly payment, includes the principal and the interest payments and fees you owe, and the interest rate you are paying. So basically, the debt worksheet is just that. It's a place where a client can gather all their bills and put down, who they owe the money to, the amount they owed, um, amount they borrowed, the amount they still owe on the debt, the interest rate, when the payments are due, the amount due, and any other notes. So it's kind of a way um, for clients to keep their bills organized and their debts organized and know exactly when each payment is due and how much. One of the things that I would probably recommend to a client if I was working with them on this is to print this out and put it on a place that they'd see it every day, like the refrigerator or the back of their closet door or something like that, because it ensures that it stays in front of their eyes and that they don't forget about making a payment due or something like that. So I would just say, put it in a place where you'd see it every day. And once they put all their debts down, there's a place for them to total the debt payment down there at the bottom. Tool number 2 is debt to income worksheet. And I talked a little bit about how this works a little while ago, but it says your debt to income ratio is like your blood pressure. Your blood pressure measures the amount of pressure on your heart. Your debt to income ratio measures how much pressure the debt is putting on your budget. It's a simple calculation. It's the total of your monthly debt payments divided by your gross income. Gross income is the amount of your income before taxes or other deductions are taken, like for retirement or health insurance or deferred compensation or anything like that. And the result is a percentage that tells you how much of your income is going towards covering your debt or the money that you owe. Another way of seeing the debt to income ratio is that it represents how much of every dollar you earn goes to cover your debt. And it gives you an example. So for example, if your debt income ratio is 0.45 or 45%, then 45 cents out of every dollar that you earn goes towards your debt. So that's a lot. That's almost half. So this leaves you with 55 cents of every dollar to cover things that aren't necessarily your debt, like rent, taxes, insurance, utilities, food, clothing, child care, and etc. And this can be used as a benchmark to take steps in reducing your debt. So it's a very simple formula. So using tool number 1, where the client can total up their debt payments, they would divide that number by their gross monthly income before taxes, and then that equals their current debt to income ratio. And whatever is left, the percentage that's left after they do that, is how much they have going out on debts. And it says understanding your debt to income analysis. So if your debt to income ratio is higher than a certain percentage, it could be difficult for you to pay all your bills because so much your income is going towards paying debts. It also impacts your ability to get credit because creditors may be concerned that you wouldn't be able to handle their debt on top of what you already owe. So, if a client is, let's say, $50,000 in credit card debt, it's very unlikely that they would be able to get another credit card because they already owe so much out to other lenders. It's an indicator to the credit card companies that the client might not have the ability to repay. Says for renters, if you're renting, consider making a debt to income ratio of 15 to 20% or less, so don't go over that. That means that your credit card payments, your student loan, auto payment, and other debt should take 20% or less of your gross income because you want to make sure that you have enough to pay rent and other bills. And it says you have court-ordered fixed payments such as child support, count these as debt for this purpose. And so a lot of the time, even though something like a child support garnishment might come right off an SSDI check or a paycheck right off the top, it's money that the client might not necessarily miss because it's automatically deducted, but it is still part of their debt and still needs to be configured in their analysis. And if somebody is a homeowner outright and not a renter, it says consider maintaining a debt to income ratio for all debts of 36% or less. That means all your debts should be below 36%. Some lenders will go up to 43 or higher. It says if your debt to income ratio is above these limits, you want to use tool 3, reducing your debt worksheet, to develop a plan to reduce your debt and lower your debt to income ratio. And we're going to go through that right now. Just one more second. I want to take another drink. So this tool focuses on some strategies that clients can use to pay down some of their existing debt. So there are two strategies to look at to reduce debt: the high interest rate method and the snowball method. Look at the pros and cons for each and decide what works best for you. And so clients have a choice on how they pay some of this debt. So the snowball method is where they pay off the smallest amount of debt first. You get rid of the smallest bills as soon as possible, and once you have paid it off in full, continue with payment, but now dedicated to the next smaller debt. So if, like, say for example, somebody has a credit card bill, they only owe $500 on the credit card, that's their lowest debt, and they're, say, putting $50 a month on it. Focus on paying that debt off first. And then once that debt's paid off, use the $50 they were putting on the $500 credit card to pay off the next debt. It might allow them to make more than a minimum payment that way. It says you create a snowball debt of payments as you eliminate each debt. How you keep making the payments, you are directing them to the next debt as each debt is paid off. So the pro is that you may see progress quickly, especially if you have many small debts. For some people, this creates momentum and motivation, and it is a motivator to keep paying your bills and paying it on time, and you see your balances go down and your credit score going up. And the con is you may pay more in total because you are not necessarily eliminating your most costly debt first. So, they might pay off a smaller credit card first, but they might have a higher interest rate credit card or higher minimum payments because they owe more on another card, and that card's not getting paid down as fast. So, a con of the snowball method is that they might be paying more in interest in the long run on a higher balanced credit card. And then, go back up. And the high interest rate method is to focus on the unsecured debt with the highest rate of interest and eliminate it as quickly as possible. So with this method, you're kind of doing the opposite of the snowball method, whereas the snowball method, you pay the lowest amount of money owed first. The highest rate interest method is paying the highest first because it's costing the client the most. And once it paid off, focus on the next most expensive. This is the pro is you eliminate the most costly debt first. In the long run, this method can save you money, but you may not feel like you are making progress very quickly because the debt's larger and it takes the client longer to pay off. So, they might not be as motivated because they're not seeing their debts paid down as quickly as they would be if they focused on paying a lower rate first. So using the debt reduction worksheet tool number 3, it says first pick your strategy. Are you going to do the highest rate method first? If you do that, you list your debts from the highest that you owe to the lowest. Or then you have the snowball method where you list your debts from the smallest to the largest in terms of what you owe. It says in the column labeled extra payment, list the extra payment you will dedicate to the payment of the debt until you have paid it off. And then when the debt is paid off, allocate the entire payment, the monthly payment plus extra payment you were making, to the next debt on the list. So going back to the example, let's say somebody's using a snowball method. They have a credit card payment of $50 a month on a small balance of $500. Once they pay off that small $500 credit card, they can take the $50 a month they were using to pay that debt and apply it to the next thing they owe. So they would list all their debts here, and under that extra payment column, they could put, maybe I'm going to put $50 more a month extra on my next highest debt. It's just a way for a client to keep their debts organized, know who they owe the money to, how much they borrowed, how much they still owe, how much they're paying out every month, and when it's going to be paid off. Tool number 4 is repaying student loans, and this is something that I can relate to. I've got a student loan myself. I'm sure a lot of us do. And it says there are two federal or types of student loans: federal and private. Federal loans are funded by the federal government, and then private student loans are non-federal loans made by a lender such as a bank, credit union, agency, or school. So in other words, private loans are a personal loan. With federal and private loans, delinquent payments will impact your credit report and result in collections. Private student loans do not offer flexible repayment terms or borrower protections featured in federal student loans. So, a lot of our clients have found themselves in a position too where they've taken out money to go to school, and then they graduate and they're having trouble finding a job. If you're a BR counselor listening to this, especially, you probably have a client that's in that situation where they have a degree in a certain thing. Maybe they can't do that same paperwork anymore because they become disabled and they're coming to DARS to be retrained to do something else. So they're in debt, for a degree that they're not using. That's something that happens a lot. But it gives you tips on how to repay back student loans if a client is in this situation. So there are many options. Obviously, do not ignore student loan paperwork, as non-payment and non-payment of bills reduces their payment options, as many repayment plans require loans to be in good standing to qualify. If a client is in arrears, the lender is not going to be as willing to work with them on flexible payments if they have a history of paying late or not at all. So the standard repayment option is one where borrowers start with this repayment plan. This repayment plan has fixed payments of at least $50 a month for up to 10 years. So what a client is essentially saying is, I'm going to pay X amount per month for at least 10 years on my loan. And then after that, some lenders offer the option of letting clients pay on an income-based repayment, where payment is limited to 10 or 15% of discretionary income, which is the difference between gross adjusted income and 150% of the federal guidelines. Payment changes, income changes, but will never be higher than the standard amount. The length of repayment can last up to 25 years, and you have missed no payments or you've caught up with payments to be eligible for this option. The loan will be forgiven. You may have to pay income tax on a portion of the loan that is forgiven. To qualify for this repayment plan, you must be able to show partial financial hardship. So this is kind of like an example that many of us have seen. If you have a client that's maybe in a Social Security overpayment scenario, where if they're on, let's say, SSDI, Social Security can hold all the SSDI until the overpayment is repaid. So, often what the clients do is say, well, I can't afford to have my whole check, taken. I can afford to pay X amount of dollars per month until the overpayment is paid off. And then Social Security often asks for proof of other income and resources and expenses, but as long as the client does pay their debt on a regular basis, Social Security will work with them and take a percentage rather than withholding their whole check. In the SSI case, it's a little bit different because SSI is needs-based. Social Security can't withhold any more than 10% of the maximum SSI check to repay back an overpayment. So it's kind of similar to that with this income-based student loan repayment, where they will agree to take only a percentage of the client's income if they qualify. Kind of same concept. And then there's the revised pay as you earn. Payment is limited to 10% of your discretionary income, but may be higher than the standard payment. Payments change as income changes. The length can last 20 to 25 years, or after 20 or 25 years of payments, any loan amount could be forgiven that's not paid. The graduated repayment is the repayment is lower the first year and then gradually increases every 2 years up to 10 years. So a graduated repayment allows a client to have lower payments in the beginning of the repayment of the loan period, and then their payments gradually balloon from there. And an extended repayment is a repayment fixed or graduated for up to 25 years. The monthly payments are lower than the standard graduated repayment plans, but you will pay more in interest over the life of your loan, and you must have at least $30,000 outstanding to qualify for this. So they're allowed to pay less if they can't afford to repay the whole amount that they owe on the loan every month, but they're paying more in the long run with that option, more in interest and over a longer period of time. So that's not always the best situation. This section talks about deferment or forbearance, and so basically payments and interest are delayed if somebody has a hardship, like they lose their job or their disability worsens or something, and they have a period where they're not able to repay, then the loans go into deferment, and they might not have they won't have a payment for a period of time, but yet interest and stuff still accrues on that loan. So over time, clients are still going to be paying a lot more. Deferment and forbearance is only a temporary respite from having to pay the debt. It doesn't save them from having to pay it. In the long run, they're going to have to pay more. Excuse me. And when I go into the tool on paying for, or the tool on focus on people with disabilities, I'm going to talk about loan forgiveness and options that people might have if they're on permanent disability. And it talks a little bit about it here, but it says you may apply for loan forgiveness, cancellation, or discharge in certain situations, including permanent and total disability. And we'll go through that in a minute. Death. So if a borrower dies, their family member can request that the debt be canceled so that nobody else is stuck with it. If a school is closed, so if a borrower has gone to a school that is no longer operating, they could possibly get their loan amount discharged. Teacher loan forgiveness if you are a teacher working in educational settings, or public loan service forgiveness after making 120 consecutive loan payments or working with the public service sector. So that's a rare situation. Depending on the job that a person has, they can have their loans discharged based on the amount of service. Should be noted that when you're talking about discharge, like in terms of federal or in terms of permanent disability, that applies to a federal loan. That is not the same as a private student loan. Private student loan options are more limited, and they might not allow for discharge like the federal loans based on disability. If a client is in a situation where they are disabled, or if a borrower dies and family member wants the debt canceled, then that's going to require them going to the lender directly to explain the situation and what happened. But it is possible to get a private loan wiped out if somebody becomes permanently and totally disabled, but it's not as easy and it's not guaranteed. Whereas with the federal loan, there's some guidelines in the regulations that allow for people to get those debts canceled a little bit easier. Finally, the last tool in this module is what to do when debt collectors call, steps that a client can take. And a lot of the time I found that when I was doing direct services, and my clients were continually contacted by debt collectors. It causes them a lot of stress and sometimes an exacerbation of the symptoms of their disability. I remember one time I had a client who was arrears on several different credit cards and things like that, and she'd always get letters in the mail saying, "You owe us this money," and she'd always bring them into me. She had an intellectual disability, and she was always convinced that they were going to lock her up, put her in jail because she owed this debt. And it really caused her a lot of stress and a lot of worry and a lot of sleepless nights. And didn't matter how many times I told her, they're not going to put you in jail for owing this debt. You just got to do your best to repay it. It didn't matter. Every time she got a letter, we'd go through the same thing again. So it's very frustrating and overwhelming for clients when they're dealing with debt collectors, especially if they have disabilities that limit their understanding. So this is a helpful section on some tips of what people can do and what they should be aware of in dealing with the debt collectors. And it's kind of what I was talking about before. So if a client has a question about a debt, that they can ask the debt collection agency for information before they send them any money to acknowledge the debt. So, for example, if the company says that the client owes more money than they believe they do, they have a right to question that debt and ask for that verification in writing before they start to repay it. So the notice of the debt that the client receives should have the name of the creditor on it, the amount owed, and the statements concerning how to dispute and seek verification of the debt. So if a client is being contacted by a debt collector in the mail, the letter that they get saying, "Hey, you owe us this money," has to have all that information in it. And they actually give a client a sample letter that I can go through with you in just a minute that they can use to dispute a debt or ask for written verification. It says, send this letter as soon as you can if there's a discrepancy or a dispute about what a client owes, if they want to fight it, if they want to question it, or if they want more information on the debt. They have 30 days of when a debt collector notifies them to fight a debt, including information regarding the validity of the debt. And most of the time it will be sent in writing. Even if 30 days pass, you can still ask for the information. So if a client gets a letter saying, "Hey, you owe us X amount," and they want to dispute it, then they have 30 days to do that. And again, going back to a Social Security example, it's kind of funny how a lot of the situations we deal with Social Security can also apply here. But like in a Social Security example, same thing. A client says, or Social Security writes a client and says, "You owe us X amount of dollars for an overpayment." They typically have 60 days to appeal. If they don't agree with the overpayment or the amount, they got 60 days to fight it. Same thing with a debt collector. If they want to fight it, they have 30 days to make contact to question the validity of the debt. So most important thing that clients need to understand when dealing with the debt collector is that if they get these letters in the mail, even if it scares them to open them, they need to open them, find out what they say, and don't just let them sit there collecting dust, because there are certain time periods they have to abide by to fight a debt. And it says, if you ask in writing before 30 days have passed, the debt collector has certain legal responsibilities to give you the information. It says, if a debt collector makes vague statements about what will happen if you do not pay, read the response letter carefully, consider to ask more details about the debt. And it says, debt collectors are prohibited from deceiving you by threatening to take actions they can't take or don't intend to. Like if they say that they're going to sue you, that you should take that seriously. It says state laws have statutes of limitations or limited time periods when creditors or debt collectors can file a lawsuit against you. These periods can be 2 years or longer. The period of time varies by state and by the type of debt. In some states, affirming debt or making a partial payment on the debt can restart the time period. You may want to consult an attorney in your state if you want to know about the limitations of making a repayment on debt before the time expires. And there's a hyperlink here that a client can use to put in their zip code and a list of attorneys that are knowledgeable on state laws on time periods to collect a debt, might be able to meet with them. So that's just a resource that clients might be able to take to find help in understanding their rights regarding how long a debt collector has to collect a debt. And then there are sample letters that clients can use, print out, and send to a debt collector asking for more information on the validity of a debt. And so you can find additional sample letters for disputing a debt, specifying how you wish to be contacted, or requesting that the collector contact you through a lawyer. And there's a hyperlink there to download some templates that the Consumer Finance Protection Bureau has put together regarding questioning a debt. And it says a debt collector may not have a legal obligation to provide all or some of the information you seek, even if you request within the 30-day period. If the collector does not give you what you request, that doesn't necessarily mean that they have broken law or given the legal right to collect from you. So a client could have the right to question a debt, ask for more information, but the debtors do have certain timelines they have to abide by, and the creditors do have certain rights. But here's an example of a letter that a client could print out and send to a debt collector if they want to question the amount or debt that says the debt collector says they owe. So it's just their name and their address, and the debt collector's name, address, and regarding, they put the account number down there, and dear whoever the debt collector is, and it says, I am responding to your contact about a debt you were trying to collect. You contacted me by phone or email. They can put in whatever's applicable, the date that happened. They could talk a little bit about what the debt collector told them. And it says, please supply the information indicated below so that I can be fully informed. And they can check off, whatever options applicable. So an example, the name, the address of the creditor whom the debt is owed. If this debt started with a different creditor, provide the name and address of the original one, the account number used by that creditor, and the amount owed at the time it was transferred. That happens a lot, whether it be a credit card or some other debt. Sometimes the debts are acquired by other companies, and so, a client might be contacted by a collection agency that they never heard of, or they might have an account with somebody they never heard of, and it's because they had a debt with another company that was taken over. So they do have the right to request where that debt came from, who the original creditor was, and the amount that was owed. Provide verification and documentation that there's a valid basis for claiming that I'm required to pay the debt to the current creditor. For example, can you provide me with a copy of the written agreement that was created for my original requirement to pay? So was there a contract or something maybe that the client signed that said, yes, I will repay the loan at these terms? The creditor would be required to provide the client a copy of any original documentation specifying that they did agree to repay the loan. And then if you are asking me to repay a debt that somebody else was or is required to pay for, identify that person, provide verification and documentation about why this is a debt I am required to pay. Like, for example, is it a debt that a spouse took out that another spouse might be required to pay for? Is it an example of somebody that co-signed something on a loan and the person that was taking the loan out defaulted, and so the co-signer is responsible for it? It could be a situation like that. And so they have a right to request further information on why they have to pay that loan. And then it says they can ask for the amount and the age of the debt specifically. And there's a whole list of things that the client can ask for there. when contacting a debt collector for further information. And then details about why you have the authority to collect this debt. I would like more information from the firm before I discuss my debt with you. Do they have the appropriate license or approvals from the state to be a debt collector? Things of that nature, and then they can sign it at the bottom. And so they can print out as many copies of this as they need to, asking for further information. Again, if a client does want to dispute a debt, they should probably do so within 30 days and ask for further information. And again, as it said up above, they can request the debt collector stop calling them. And even though that doesn't cancel the debt, the client still owes it, and they don't have to be harassed. And it says you might not want to make this request to stop contact if the debt is your home mortgage company, because obviously, you want the clients to stay in touch with the person that's servicing their mortgage. If they fall behind, that's something that's obviously essential. And you don't want the home mortgage companies to cut off contacts, because then obviously a client could find themselves in a situation where they lose the house if they fall too far behind and they're not in constant communication with the lender. Here's another letter that a client can use to ask for more information on a debt. And then it says your benefits are protected from a garnishment. This goes back to what I said a couple minutes ago about the differences between SSI and SSDI benefits and protections. This is if a debt collector sues you in court and gets a judgment, then you can ask your bank or credit union to turn it over to your bank account. This is called a garnishment. So if somebody is sued and they have a court order saying they owe the money, then the client can set it up with their bank or credit union for the person they owe the debt to take the money right out of their account. So Social Security, VA benefits, and other certain federal benefits are generally protected from a garnishment to pay a private person or company. And again, where it says Social Security and VA benefits, when they say Social Security, again, that does not mean Social Security disability. They're talking about Social Security based on age. So basically Social Security retirement, VA benefits, SSI benefits, ones that are based on need are protected from garnishment. But depending on the debt, SSDI benefits are fair game. This is if you receive these benefits and they are your primary source of income, tell a collector when the collector first calls you. And when a collector knows that they cannot garnish your benefits, the collector might be less likely to sue you to collect the debt. And that's going back to the example I told you about my client who was on public assistance. Once I called and advocated on her behalf and I sent them the paperwork verifying that her only income was public assistance, then they stopped collecting the debt. They stopped contacting her and trying to collect the debt because they knew that they couldn't garnish her public assistance benefits. So that's an example of how that might work. There are exceptions for the collection of child support and debts due for federal or state taxes. Child support can be fair game, and also any income taxes that are owed to the government. Debts that are protected are things like credit card bills. If somebody gets behind in their credit cards and they're only on SSI or Social Security, they might not be garnished, but if they owed like the federal government money, then that could be fair game. There's a hyperlink here that you could investigate in your own time if you're interested on some of the exceptions on those protections and when a client on benefits is expected to repay. And this is what you can expect. Even if your income is protected, a collector can still communicate with you and ask you to pay the debt. So they know they can't garnish your benefits, or in this case, they know they couldn't garnish a client's benefits, but that doesn't necessarily guarantee that they're not going to ask the client to repay it in some other way, such as making a payment plan. If your benefits are protected from garnishment, you may have options. So remember, the debt collector, remember to let them know that your primary source of income is federal benefits. So if somebody's on public assistance or SSI only, the debt collectors need to know that. And it says you can use this letter up above to tell a debt collector that you receive income from Social Security or VA. You know, when they contact a debt collector via a letter asking for more information, they can put in that letter, you know, I am on Social Security or VA benefits or SSI or some of the other protected benefits. They can use that to make the creditor aware. Here's a copy of that letter. So it's just the client's contact info, the debtor's contact info, the account number for the debt that the client has, and that's it says I'm writing to you about the debt that you're trying to collect and what they told you, and please indicate that my income comes from protected federal blank. They can put in there Social Security, SSI, VA benefits, whatever. These benefits are protected from the garnishment. If you forward or return this debt to another company, please provide this information to them. So they can use that letter to make the debtors aware that they're receiving federal benefits and they might be protected from garnishment. Okay, and the next module goes into module 7 on understanding credit reports and scores. We'll go into that one next month. But I felt like there was some really handy tools here, some really straightforward tools that a client could use to both manage their debt and communicate with debt collectors, things that they could print out and use as resources to get the information they need on their rights and their responsibilities regarding paying back a debt. But the last thing I wanted to do before I end the webinar is go through a closer look at the total and permanent disability discharge. And this is on page 67 of the Focus on People with Disabilities guide that supplements the Your Money, Your Goals toolkit. And it talks about some of the loans that could be discharged if a person is totally and permanently disabled. So like William D. Ford federal direct loan, so a federal education loan, a federal Perkins loan, or a Teach grant. And it says before federal student loans or grants can be discharged, the person with a permanent and total disability has the burden of proof in proving to the debtor that they are permanently disabled, and they are required to request in writing that their loan amount be discharged and provide documentation that they are permanently and totally disabled. So part of that documentation requirement could be a copy of their SSI or SSDI award letter showing that they get SSI or SSDI payments based on a permanent and total disability. It could be a physician statement if they're not necessarily on Social Security, but they are disabled. They have a physician that would certify that they're not capable of working and earning over SGA. You know, that could be a way to prove it too. But typically, to qualify for a loan discharge based on permanent and total disability, the disability either has to expect to be end in death or last for at least 60 months. You know, it's not like a situation where somebody breaks their leg and says, oh, I'm disabled, I can't work, I need to have my loan amount discharged. We're talking about permanent and severe disabilities here that are expected to last at least 5 years and render them either incapable of working or at least earning over the 1180 SGA figure. And there's some information on how to apply for the discharge. If a person is in a situation where they're totally and permanently disabled and they want to apply for a discharge, they can contact the Department of Education. The contact information is there. or send an email to the email address listed here, and they will be provided an application that they would have to return to the education department along with a proof of their disability via SSI, SSDI award letter, or physician statement, or what have you. I actually had a case like this just come up recently where a VR counselor helped a client, or at least gave the client information about the discharge, but then the Department of Education came back and said, well, based on our investigation, we determined you still owe the money. And it was because even though she was on SSDI benefits, she had failed to provide that documentation to them at the time that they applied for the discharge. And so what she had to do then was ask for a review of the case, submit the proof that she was on SSDI, and then they reconsidered it. So the burden of proof is on the client in that situation if they want the discharge. And again, this is only applicable if a person is permanently disabled 5 years or more, or has a disability that's going to end in death, and if they have a federal loan. Private loans are a different story, and they might not be subject to the same loan forgiveness as the federal loans do. And then there's a tool on the debt worksheet. And this is what we've seen in other modules where a client can list down all their payments and money they have going out, different debts they have. But what makes it a little bit differently in the focus on people with disabilities guide is there are some sections on debts that people with disabilities may have that other people might not. So like there's an example of a column on here for assistive technology payments and medical debts and things like people without disabilities might not have. So this worksheet's a little bit more detailed than the one in the standard Your Money, Your Goals toolkit. And then this next tool is on dealing with debt collectors, and it just handy dandy one-page fact sheet that clients can be provided with. It's like, be sure that you know who is contacting you and why. Ask for all their contact information, ask for them to verify the amount that's owed, and then resolve it as appropriate, whether you work out a payment arrangement or whatever. So it says be sure, ask questions, and then once you gather all the facts, then working on a resolution. And there's a little paper here that a client can cut off and use to respond to a debt collector. It's like, I don't think this is my debt, or I don't agree with the amount, or I've never heard of your company and I don't owe this, whatever the case may be, and they can send it off in response to the collection attempt. So that is Module 6 on the dealing with debt and debt collectors. I will be doing Module 7 on understanding credit reports and scores shortly, probably sometime in July. That's also going to be a really interesting one, and look at some of those tools because a lot of the clients that we're working with don't fully understand their credit reports or their scores, and that's kind of why we've developed tools like the financial health assessment to help them access those reports and work on some of their financial goals. So I'm really looking forward to doing that webinar as well. As always, if you have any questions about the tools in Module 6 or any of the other tools in the toolkit, you can always email me, Michael, M-I-C-H-A-E-L .Klinger, K-L-I-N-G-E-R @dars.virginia.gov. You can call me 434-298-7652. I would be glad to walk you through any questions you had on any of the materials in the modules. Thank you for your time, attendance, and participation, and I look forward to doing Module 7 next month. Thank you, everybody. Bye-bye.